Let's take you live to this now. Justice and Correctional Services Minister Ronald Lamola will this morning receive 4 reports from the South African Law Reform Commission. The South African Law Reform Commission conducts research into all branches of the law in South Africa. Included will be reports on sexual offences like pornography and exploitation of children, as well as a report on the practice of ukuthwala. Let's take you there live.
Share the work of the Law Reform Commission on 4 very important topics which have wide range effects on how we dispense justice or how justice is administered in this country in various respects. I'd like to call upon Minister and Justice Colopin for a photo opportunity as Justice Colopin hands over the reports to the Minister of Justice. Thereafter, Justice Colopin will make a couple of remarks followed by the Minister of Justice. So you can just stand here. Yes, thank you very much. Justice Colopin, you have the floor.
Good morning, everybody, and thank you for the introduction, Mr. P. Minister, Deputy Minister, Secretary of the Commission, full-time members of the Commission, and researchers of the Commission. We've looked forward to this day for some time now, and the handover of the reports that was just concluded to the Minister represents an important phase in the completion of the work of the South African Law Reform Commission in 4 important areas that affect our law, but also that impacts on the daily lives of people in our country. The Law Reform Commission is established as the primary agency for law reform, and the mandate of the Commission is to be the principal body undertaking law reform. We receive requests from the executive, from members of the public, from political parties to undertake law reform in specific and particular areas where the lacuna in the law has been identified, or indeed where the law may be said to be out of sync and out of touch with the Constitution and the values that it espouses. The Commission would undertake an assessment and would undertake, if merit is found to be present in the request, an intensive process of law reform. And often that process takes much longer than what people desire. People seek law reform to be much more speedy. But the process of law reform is time-consuming because in a society such as ours that prides itself on a system of participatory democracy and a system of proper public consultation, it may be said that the processes of the Commission are slow, but deliberately so, because it seeks to ensure to the greatest extent possible that all voices are heard, diverse voices, all views and opinions are canvassed. And in a society such as ours, it can't do that in a formalistic fashion by simply putting out a document in the public domain, saying to people the document is available on the Commission's website and you're invited to make a written submission. That may work for parts of our society, but it doesn't really work for the rest of society, in particular where people don't have access to the technology, where the technicalities of the law are often beyond them. And so the Commission undertakes careful public participation processes. If it means travelling to far-flung villages and towns to hear people's views and their voices, then that's what the Commission does. And so the process, by its very nature, then is extended, but we hope at the end of the day it is a process that properly reflects the attempts of the Commission at least to hear and to consider all views ranging from academics, practitioners, those involved in the sector, and ordinary members of the public who have an interest in the law and in how the law unfolds and how it impacts on their lives. And so today it is with great pleasure that we were able to hand over 4 reports to the Minister. The reports cover diverse areas, and without indicating any order of preference, the first report, which is Project 138, is the practice of ukuthwala. Now, the practice of ukuthwala can be described in the most simple terms as the forced taking of a bride. And the report recognizes that some features of the practice may have had a benign origin, where a young man and a young woman fell in love and decided they wished to spend the rest of their lives together. But there were obstacles to that happening, either on the part of the family, either on the part of protracted and stalled Lamola negotiations, and so practice evolved, benign in its origins, where the young woman would be taken, not kidnapped, but she would be taken and brought to the family of the young man, and she would live there amongst the other women, and that would create a situation where the family of the young woman would be almost compelled to come and seek her out and to enter then into bona fide negotiations for the marriage to be concluded. But over time, some features of that practice deteriorated to the extent that the notion of consent in some instances simply lacked. People were taken without their consent. In some instances, young children were the subject of the distorted form of ukuthwala. And following its research and following a request to undertake the investigation, the Commission produced a report which seeks to recognize, on the one hand, the benign and some of the positive features of the practice, but on the other hand, to ensure that the practice was not used to force people into marriage, or indeed was used to prejudicially impact on the rights and the interests of children. And that broadly is the ukuthwala report. The researchers responsible for ultimately putting the reports together, even though they carry the Commission's stamp of approval, are all present here today. And if there are more detailed questions, they have been briefed and be willing to take on board those questions. The second report, Minister, is the report on prescription. And prescription is a controversial but important feature of our law, because on the one hand, it almost acts as a guillotine in terms of when claims may be brought. That would be claims arising out of a justiciable dispute and that result in litigation. And our law has historically, and for good reason, set timelines within which those claims may be brought. And generally the period is 3 years. The problem with prescription laws is that different laws provide for different periods of prescription. In some instances, an action must be brought within 6 months, failing which the person would be non-suited to bringing the action. In some instances, 2 years. In some instances, periods between 6 months and 2 years. And so the idea of regularizing prescription periods to ensure equitable access to justice is certainly an important one. But on the other hand, the need to ensure efficiency in litigation is also an important one. It wouldn't help if a claim was brought 10 years down the line. It may be a valid claim, but it wouldn't be fair to a defendant to have to defend a claim brought 10 years after the occurrence, because documents no longer exist, memories have faded, and the idea of having a fair hearing in a court of law would not certainly be possible under those circumstances. So, again, as in many areas of the law, it requires a fine balance. But the report also raises other difficult issues. Once a claim has prescribed, is it incapable of being further enforced? Should a court take notice of prescription under those circumstances? And the report traverses a number of those issues and offers various options for law reform. In much of the work that we've done, there always isn't a definitive answer. Sometimes there is, but sometimes in the public consultation process, two very viable options may emerge as possible routes for law reform. And the approach of the Commission generally has been to capture both those and to speak to the merits or otherwise of both those and put them out in the report, so that at least the executive has available options, and in the process that follows the completion of the reports, there are options available with regard to possible areas of law reform. The third report deals with sexual offences, pornography and children, and it deals with the production of pornographic material involving children, the dissemination of that material. And I think in a growing age of ease of technology, one sees the impact that this could have on the broader society, but also on the interests and the rights of children. And given that our Constitution carries within it the paramount principle that the best interests of the child matter and matter significantly so, it's an important area for us to consider in the context of our society. And the report covers a variety of areas in how the law could best regulate that with a view to protecting children, but also recognizing that children themselves may be involved in the production of this material, as children are naturally curious, and how best to deal with that other than through the strictures of the criminal justice system, but in recognizing that we need to deal with children in a way that recognizes their youth, their vulnerability, and the need not to stigmatize them permanently. The final report, Minister, is one that may well evoke considerable public debate, and that's the report on legal fees and access to justice. And the Commission's mandate to undertake this work arises out of the Legal Practice Act. And I suppose it goes without saying that in a constitutional democracy that prides itself on the rule of law and on access to justice, people's ability to access the system of justice is largely dependent on their ability to access the legal system, to access lawyers, and to take their justiciable disputes to a court of law or to any other tribunal that can resolve them. But increasingly, the cost of justice has simply put that right beyond the reach of many. And so it rings hollow when someone who's lost their home and who's been unable to have his or her day in court, not because the doors of the court are closed physically, but simply because access to justice is so prohibitive from a cost point of view. It undermines the very notion of having a right to court, and in turn it undermines the very idea of a constitutional democracy that can be held up as saying that we are all equal before the law. Some might validly ask, well, are some more equal before the law than others, given the enormous disparity of resources and the significant inequalities that remain in our country? So that report seeks to address a number of issues. It seeks to ensure that the system by which we resolve disputes can become more efficient, perhaps more cost-effective, and a number of recommendations go towards the functioning of that system, the functioning of the court system, the greater use of mediation as a means to resolve disputes, the greater efficiencies in court systems with regard to how courts manage their role and how they ensure that matters that come through the courts can be dealt with efficiently but expeditiously. But at another level, it goes to the cost of legal services, and that speaks largely to the legal profession. And it seeks to carve out a dispensation that would ensure that at the one level, at the very high end of the scale, those who can afford to pay legal costs as determined by practitioners should be able to do so. So if a multinational company comes into South Africa and wishes to engage one of the top law firms with regard to advice on a takeover, and if it would cost them an X amount of money and that's what they're able to pay, then many respondents in the work we've done said, you don't need to interfere in that process because that doesn't impact on access to justice. But for many that would fall within the lower and middle income groups, access to justice is a formidable challenge, and the report seeks to find means to reduce legal fees and to place certain caps on the scope and extent of what law firms and legal practitioners may charge to people in those categories of users, but in particular when those services are being used, for example, in the magistrate's court. And the idea is that at that level there could be a strong case made for a reduction, or at least a set of guidelines that would regulate fees. And in saying so, this is mindful that the legal profession needs to function and that sustainability is important. But I think at the end of the day, this is not only about one sector. It's not only about lawyers. It's about all of us as a society. What is it that we can, what is it that we must, and what is it that ethically we should be doing to ensure that the reach of the law is not taken beyond the people who seek justice. And so I hope that report is received in that spirit, that it's not an attempt to regulate, it's not an attempt to narrow the scope within which lawyers can function, but rather it's aimed at a broader level of ensuring that ultimately, if our democracy must flourish, and if it must succeed, and if it must deepen, then ordinary people who are grieved and who feel a sense of injustice must be able to feel that they're able to access the mechanisms of justice. And I think most of us would agree with it. So, Minister, it's been a pleasure and honor for us to work on these difficult areas. But what it has done, it has taken us sort of close to the heartbeat and the pulse of the nation. It has exposed us to their fears, their insecurities, their hopes and their aspirations. And we hope in all of this we've put together something that could be of use to you and your government in taking the issues forward. I think I'll stop there, Mr. Piri. I may have gone beyond my time, and I hope I also get a copy of that constitution. You've offered it to the media, but you will. Thank you.
Thank you very much, Justice Colopan. The constitution is in your head, so something you know back to front. So if you can keep that copy.
Thank you.
Minister, we've heard remarks from Justice Colopan, and essentially said, here are the reports, what will government do with them, what's the way forward. I think your remarks may then elucidate members of the public on that aspect. Thank you.
Thank you very much, Crispin. The Deputy Minister of Justice and Constitutional Development, Justice Colopan, who is the Chairperson of the Law Reform Commission, the Secretary of the Law Reform Commission, commissioners, researchers from the Law Reform Commission, members of the media. Today, the Law Reform Commission releases for the public and for government 4 critical reports, which proposes recommendations with far-reaching implications for the law and various legislations in our country. More importantly, will have a significant impact on the lives of South Africans. Historically, there have been a major discrepancy between the content of the law and the ideal of justice. This is the task that the Law Reform Commission is seized with. The content of the law must by all means possible match the ideal of justice. They are a bridge between that community and the law, and to help narrow that bridge and the gap. The South African Law Reform Commission is a bridge between the people and the law, and the Commission is tasked with research with reference to all branches of the law in order to make recommendations to government for the development, improvement, modernization, or reform of the law. The law is not static, nor is it forever cast in stone. The laws that apply in a country must be dynamic and subject to regular review and improvement when the need arises. As society changes, so must the law, constantly improving, asking what works and what doesn't, and if and how it can be improved. For the law to remain relevant and useful to society, it must be monitored and followed by extensive research and proper consultative processes. Government is therefore informed by pragmatic advice on the efficacy and desirability of the law. And government also needs to be alerted to any unintended consequences of such proposed legislation. Today we are presented with the 4 reports which addresses various gaps in our law. As Justice Kolapen has stated, the first Project 107 report on sexual offences, pornography and children. The second project, the report on Project 142, investigation into legal fees, including access to justice and other interventions. The third project, the report on Project 138, the practice of ukuthwala. The fourth project, the report on Project 125, harmonization of existing laws providing for different periods of prescriptions. These four reports go a long way in analyzing systematic problems in our justice system and in society and recommending an appropriate legislative remedy to address these challenges. The report covers issues which are at the heart of access to justice, the distortion of cultural practices, and the ability for claims to be justly adjudicated, and regulation in relation to child pornography and access to such material. We welcome the research, the investigations, and the recommendation as set out in the reports, as we consider the necessary legislative changes, amendment bills, and the regulations. And as government, we will go through the reports and process them through in our systems for necessary legislative changes, and also to take them further for public engagement in those legislative processes, and to engage with all the relevant stakeholders, including other government departments affected by the reports of the Law Reform Commission. Thank you very much, Chair.
Thank you very much, Minister. Colleagues, we've now reached that point where we can ask questions and seek clarity from the presenters today. So, see, Barry, your hand is up, and I just want to get an indication from those who are managing online platforms. Takalani, yourself, do you have any questions there?
Thanks. We do have questions from online platforms.
Okay, can we just start with you? Can you give us 5 questions, please, from the online platform?
So far, I have 3 questions, all coming from Marvin Adams, who is a freelance journalist. And the first question is, has the department, the DOJ, looked at the role of community advice offices? Because very often this is the first point of access to justice. And the second question is, has the department looked into paralegal and what role it would play in access to justice? And the last one from Marvin Adams is, does the department plan to look into funding of community advice office?
Okay, so just repeat them again, please. We went fast.
My apologies. The first one was, is the DOJ looked at the role of community advice offices, because very often this is the first point of access to justice. And the second one is, the department looked into the paralegal and what role it would play in access to justice. And the last one, does the department plan to look into the funding of community advice office? Thanks.
Thank you. Barry will also take you.
Thank you. Good morning, Justice Colton, Barry Bateman from ENCA. I'm looking at the proposed, the recommendations related to the Sexual Offences Act, the consolidation of various criminal acts that is already touched on or catered for in different pieces of legislation, such as, and you mentioned here, the Film and Publications Act, as well as the Cybercrimes Act, which was actually welcomed when it was introduced by the various lobby groups. Can you just give me an idea of the rationale, the benefit that it would have to our courts, and of course the NPA, who would be, seized with enforcing or prosecuting these crimes, of having the laws consolidated into a single Sexual Offences Act? Thank you.
Okay. Thank you very much. I think we will do this. We'll start with the Department of Justice questions. We're also joined by our almost retired DDG for court services in the room. So I will defer some of the questions to him, then followed by Deputy Minister and the Minister, and then the specific questions that are put to Justice Colopin. Justice Colopin can answer, and of course, if Minister and Deputy Minister also want to provide clarity on those aspects, they also could. So we'll start with our Deputy Director General for Court Services on the question of access to justice and the role of paralegals and community advice officers. Please. You can just press the mic from there, it should work. Excuse me? Oh, okay. So can you come here, DDJ?
Thank you for the opportunity. The greetings to all. Let me start by saying that obviously when the Legal Practice Act was enacted, there was always a need to come with a similar legislation that will regulate paralegals. And I think that discussion is still ongoing, Minister, and I think it's one of the outstanding principles. And our department is running a program that looks into a legislative framework that will recognize the role of paralegals in society, as we know that paralegals provide a very economical and cost-effective form of representation to communities. And I think very soon there will then be a process of the department coming back with their proposals on the role of paralegals. And the second point, and I think that the Deputy will also reflect on it, is the role of the community advice offices. Those offices have been there for a long time, and I think there have been a debate with National Treasury to what extent can those offices be supported. And I think what has emerged in the policy discourse is that instead of supporting community advice officers in terms of what they do on a daily basis, it will be easier if they engage into partnership project with the government, so that the funding is not to the community advice officers themselves, but is the programs that are geared to assisting communities, etc. Because obviously the fiscal is stretched, and I think to support the advice officers really need in terms of their infrastructure, their salaries, whatever, will basically be unaffordable. And obviously not only unaffordable, but also will create a burden on the national fiscals and on the taxpayers' benefits. But obviously there are avenues where community advice officers can partner with the department, with government and the department, and take over certain programs on access to justice, which can basically leverage and assist and enhance the government's initiative to increase access to justice. And I think there are engagement with the community advice offices to see which programs can better take that process. And the next point, that the government and the department in particular assist the community advice offices in terms of accessing other funds which may be available from certain quotas, including donor funding, which may basically be made available. And I think that's the area where we need to play a very robust role in ensuring that we assist them to access those funds wherever those funds may come from, etc., but not directly from the fiscals. But I'm sure, as I've said, the Deputy Minister will look into will reflect on the aspects which are part of the ongoing program in the department. Thanks.
Ian, any remarks? Oh, okay. Linda as well from the South African Law Reform Commission, just before the Deputy Minister comes.
Minister, Deputy Minister, Justice Colopin, and all protocol observed. I'm going to respond to the first question around the role of community advice offices. I think arising from the investigation into legal fees, our recommendation is that community advice offices, remember community advice offices are mainly manned by paralegals, and the recommendation from the investigation is that these offices must be one of the structures in respect of which community services must be provided. Remember, community services is provided by your attorneys, advocates, Now, the LPA current section 29, subsection 2, it only makes provision that community service be provided in the Human Rights Commission only. Now, arising from the investigation, we're saying we must expand to these institutions where community services is provided. And we are saying that all Chapter 9 institutions, including community advice offices, those institutions must be used as places where community services must be rendered by legal practitioners for free. I think that is my input. Thank you.
So there just seemed to be a number of, so many replies for well, it was 3 questions, so I guess it's 3 people responding. I think a lot has been covered. Just to highlight what Advocate Skosana said, there was a chapter before the legal practice bill came to Parliament. There was a chapter on paralegals, which was then taken out because of, as it was before my time even, I think it was objections from the profession. But there was an undertaking that there would be legislation on that. There is legislation in our legislative program for this year, although it's only expected to come out towards the end of the year for introduction into Parliament. But there is legislation on community advice officers and paralegals. They are an incredibly important facility. Obviously, sustainability is a problem. Community advice officers, I think, in principle, won't accept any payments or can't accept any payments for their services, so the sustainability becomes more difficult. There was a study done on sustainability by the Foundation for Human Rights, which actually looked at a number of these officers are already getting funds from government for other work. Department of Labour, Department of Social Development, Department of Health, etc., on HIV/AIDS issues. So I just wanted to add those points. We do recognise community advice officers and paralegals as extremely important. There will be legislation hopefully introduced before the end of the year, and there has been work already done on the issue of sustainability. Thanks.
Very briefly, I think, Mr. Bateman, the idea, yes, is that one should ideally, for the sake of coherence, for the sake of having one effective piece of legislation that encompasses all the various components of what we may regard as sexual offences, has merit in it. It has merit from a coherent prosecution strategy, but it also has merit in terms of its public education potential, that somehow we don't sort of create a hierarchy of sexual offences. If we believe in the integrity of people, their physical and otherwise their integrity, then the concern must be an equally strong one across the board. Different interventions might be required in different areas having regard to the vulnerability of people, but that's the broader objective, as you correctly identify. And Mr. Dean Clark, who's sitting right behind you, might want to say a word or two about that. But I know we said there were 3 questions and there were 4 responses, but can I just add to the question of paralegals, its critical role, because very often, and I've experienced this in my work as the head of the Human Rights Commission, but also as a judge, that often people who have a legal problem don't necessarily need a lawyer to resolve that problem. That doesn't mean that you offer people a different quality of service or a different quality of justice, but very often it must be ascertained by what is the nature of the problem. So someone who's having a difficulty in accessing a grant, for example, could well be assisted by a paralegal, because the intervention at that stage may simply be an intervention with a SASA office or a government department to unlock a blockage. In the absence of a fully functional sector of paralegals, that person might be directed to a lawyer, and that simply will sort of not work because the costs are exorbitant, and you don't need, you may need a lawyer for other purposes. And so I think that's the thinking behind that, and I think in the apartheid era, paralegals, community advice officers played a critical role in sort of just being there to provide support to communities, to individuals, and in making the difference. So I'm happy, and I think we support the initiatives of the department in this process with regard to the recognition of paralegals, support of paralegals within a broader framework of uplifting communities as opposed to identifying that simply as a standalone service. Yeah. So, Nadine, I'm not sure if you wish to say anything else in response to Mr. Bateman's. Yeah, thank you.
We're coming out of that briefing relating to a project the SA Law Reform Commission has over the years been engaged in investigating various aspects of prescription and law concerned with limiting the time within the rights that must be enforced in the interest of legal certainty and finality and timeous exercise of rights and prompt adjudication of disputes. Of course, looking at several cases, they're handing the Minister of Justice 4 reports back just in relation to the gaps in this space.